Indeed. Okay, so are you ready to hit record? We are recording. So with that, I'm ready to get started whenever you are.
Yeah, that's fine. Go ahead.
Okay. Well, welcome everybody to a meeting of the Judicial Review Committee. We actually start off our agenda with calling the roll. This staff council will call two rolls. The first roll will be the names of committee members and alternates of committee members. And then the second roll will be of AGUS members who are not on the committee and their alternates. After each name is called, we would appreciate it if you would say here so that we can make sure that your microphone is working. With that, I will turn it over to Bobby.
Yeah, good morning, everyone. Thank you for joining us. I'll go ahead with the roll. Boris Burstein.
Here.
Judge Braden, Susan Braden. Betty Jo Christian. John Duffy. I do see Professor Duffy, but we like to make sure that everyone's microphone is working. So feel free to jump in if you resolve that. Don Elliott.
Here.
You. Aaron Hawley. Paul Kamenar. He's joining by phone.
Here.
Hi, Paul. Thanks for joining. Ron Levin.
Here.
Albert Lynn. Mary McQueen. Dr. David Michaels. Stephanie Middleton. Jeffrey Manier. Alan Morrison.
Here.
Judge Randolph Moss.
Here.
Victoria Norse. Lee Lieberman Otis. Deborah Perlin. Judge Plager. Judge Rommel. Eugene Scalia. David Shonka. John Siegel.
Here.
Stephanie Tatham. Drita Tanuzzi. David Trissell.
Present.
Andy Vollmer.
Here.
Cheryl Walter. Kenny Wright. Allison Zeeve.
I'm here.
All right, and then our next list, Sharon Pacino. I saw you. Just make sure your mic is working so you can join the discussion later.
Here, thank you.
Mike Bunger. Mary McQueen's alternate. Diana Hobbs, alternate.
Here.
There you are. Joe Salome.
I'm here.
Alternate.
Here.
Lawrence Rothenberg. Dennis Fan. Jeff Lubbers. I believe I saw you. Perfect. Bill Funk. Saw you.
Here.
Jay Ortiz. All right. We are all set, Kristen. I'll monitor the attendance otherwise if people are trickling in. So back to you.
Wonderful. I appreciate it, Bobby. And for those of you who are neither ACUS members or who are not ACUS members or their alternates, staff is not going to call your names at present because you do not have speaking privileges. So just be aware of that, although we appreciate your attendance. If you want to participate in our discussion, if you have any technical difficulties during the meeting, please reach out via the chat function or via email to ACUS staff. ACUS staff will be happy to assist you with troubleshooting or moving to alternative means of participating in the meeting. Next, I'd like to turn to our Vice Chairman and Executive Director, Matt Weiner, to deliver opening remarks.
I'm sorry, Kristen, I had a small technical problem. I'm going to forgo opening remarks and turn it back to you. I know there's some initial scoping questions that may need to be addressed. And I don't want to take any of the committee's time with opening remarks that won't contribute to our discussion much. So back to you.
Okay.
With the one exception that I do want to thank not only you and all the committee members, but especially John for drafting so well the current version of the recommendation, including some of the new language in the preamble. So thank you, John.
Indeed. And I do need to note that John Siegel, even though he is a member of the Committee on Judicial Review, is recused from voting today and is participating in this meeting solely in his capacity as a consultant, although I anticipate that given his role as the consultant on the project for discussion today, that we will be hearing from him and we will appreciate his participation. Before we turn to the substance of our meeting, I do need to go through a few of the ground rules for our discussion. Please do note that only ACUS members, which includes government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels, whether or not they are on their committee, and their designated alternates, all have full speaking privileges. To avoid background noise though, since we are on Zoom, I would ask that you keep your microphone on mute and either use the hand raising feature on Zoom or add a comment into the chat feature if you would like to speak. I will then call on you and you can unmute yourself. Please then remute yourself when you're done. We've noticed in the past that people have issues with Wi-Fi, and this will help us to maintain this meeting as best we can, with respect to the technology. I'd also like to ask ACUS members and their designated alternates to use their webcams if possible. I do recognize that in some instances for having to do with Wi-Fi connections, it may be that using your video feed will cause technical difficulties, but to the extent that we can use our video feeds so that we can see each other, I think that that would be helpful for our discussion. With respect to attendees other than ACUS members and their alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points, and we will presume that committee members consent absent their raising an objection. If any such participant would like to speak, please indicate that you would like to speak on the chat feature or by using Zoom's hand raising feature, and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you're done speaking. For all participants, please use the chat function only to indicate that you'd like to speak, or for committee members and their alternates, perhaps to vote when asked to vote. Please do not hold sidebar conversations or put substantive comments in the chat feature. Not everyone who's participating may be able to access those. And it just makes the discussion very confusing when we've got two different conversations going on at a time, one orally and one in the chat. In the event, so only members of the Judicial Review Committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee. Bobby and I both have a list of committee members in case you are unsure. If you want to know your status, please don't hesitate to reach out to ACUS staff by email or in the chat, and we'll do our best to let you know your status. In the event we do take a vote, please remember that only members of the committee and their designated alternates have voting privileges. If you take a vote, we will either do a show of hands or ask a member to, using the hand raising feature, or we may ask members to put a comment in the chat feature. We'll see when we get there if we need to take a vote. Hopefully we won't need to take a vote today, except perhaps to vote to move the proposal forward to the plenary if we can get that far. We will see. So moving forward, are there any questions about any of that before I move forward into the substance of the meeting? Okay. Seeing none. So moving forward into the substance, if you'll recall at our last meeting, we went through the various recommendations item by item, focusing on the specific language that was being used. We still do need to resolve several issues with respect to those recommendations, and we also need to go through the preamble. But before we get there, we did have a few broader issues that had been raised in comments that we did not get to in the last meeting. And I would like to start this meeting by addressing some of those broader items, after which we will turn to the recommendations, and then we will turn to the preamble. I do want to thank everyone who took the time to write up and send in comments. Some of the comments that were received relate to specific lines or items in the preamble and the recommendations. So I will defer consideration of those comments until we get to the recommendation document itself. But turning first to the broader comments, let me say, and some of you who chimed in a little earlier may have heard this, I've done my best. There seems to me to be a fair amount of overlap between some of the broader comments that were received. I have done my best to group them together where it makes sense to do so, but it's entirely plausible that my effort to do that failed, that I grouped together two things that shouldn't have been grouped, or that I failed to group together something that should have been grouped together. I'm just going to do my best, and if you think I've gotten it wrong, please feel free to chime in as part of the discussion. But let's start off with first a comment from Council Member Ron Cass. So Ron has asked us to consider whether it would be a good idea to draft a provision that requires a general requirement that where there are differences in specific procedures between the Administrative Procedure Act and a statute enacted either after the Administrative Procedure Act or after the date of the law containing the general rule, or after some other specified date, then the more specific statute shall be construed as adopting APA procedures, unless the APA procedures are specifically referred to and rejected in the specific statute. I think of this proposal as similar to APA Section 559, as an instruction to reviewing courts to apply the APA unless Congress clearly prescribes something different. Ron made clear in his comment that he wasn't sure whether we should do this or not. It struck me at least that Ron's comment seemed somewhat related to a comment submitted by Senior Fellow Paul Kamenar, that if a statute doesn't provide for any judicial review, then the judicially created default rule is to file in the district court with de novo review of the agency record, but some litigants unwillingly file file for a review in the courts of appeals instead. So Paul suggested an omnibus statute that judicial review, unless otherwise specified, should be in the district court. I'm agnostic as to these questions. I'm not sure that they're entirely germane to this particular proposal. Paul did send in additional language for footnote 5 in the preamble, and it's not entirely clear to me whether that additional language was intended to reflect that point or a different one. So I believe, is Paul with us?
Yes, can you hear me?
Yes, and I think Ron may be with us as well, but on the phone. So I would ask for Ron or for Paul to, to help me out here in terms of whether these go together and whether they relate to that proposed language on footnote 5. And we can pop that language up on the screen. I know that Bobby has it ready to go so that we can look at the language that Paul sent in earlier. So, let me call, I think Ron is on the phone. So let me call on Ron and then I'll call on Paul.
Thank you.
Ron Cass, are you available? Okay, maybe not. So maybe I need to call on Paul then.
Yeah. Okay, thank you. Yeah, no, my original suggestion back in December was, whether or not this recommendation was going to address all those instances where judicial review is allowed, to occur, but there's no specific statutory provision, and whether we wanted a omnibus statute that would say something like, in all other cases where judicial review is not excluded or provided for, and have some kind of language that harmonizes with what you're recommending as well in terms of where to file, what time to file, et cetera. But I think, as you were suggesting, that maybe this is something that maybe we may not want to get into, in which case this morning I submitted a proposed language that's when we have there in footnote 5 where you cite to the APA to have language that disclaims that we're getting into that whole issue, and just simply say that the APA provides for a right of judicial review of agency action by aggrieved parties in courts of competent jurisdiction when there is no statutory provision either expressly granting or precluding judicial review, period. This recommendation does not address when, where, and how such actions may be filed. That just sort of either making clear that we're not getting into that, and I think that will be fine. But I'm indifferent either way, whether you want to make that clear or whether you want to actually get into substantively whether we want to address that whole issue of non-statutory review. That's all I have.
Thank you, Paul. Bobby has put Paul's proposed language up on the slide. It's in the bubble comment, or up on the screen. It's in the bubble comment. I hear some noise in the background. I'm not sure whether that was Paul's phone or if Ron Cass is with us. Let me look again and see. Doesn't look like, I can't tell that Ron is with us, but Ron, if you are, please feel free to chime in. Otherwise, I would ask if anybody else wants to weigh in on either the scope of this or the language that has been proposed by Paul for footnote 5. I will call first on Don Elliott.
Yes, thank you. I support the idea of making clear that we're not getting into the question of the form of judicial review if statutes are silent. I do that in part because if we get into it, I think we should take seriously the question of whether or not the default should be in the district court or in the Court of Appeals. There's a long history on that, and I think with regard to rulemaking or review on a record, there are strong policy arguments that review first in the district court is duplicative. And I just don't think we are prepared to get into all of those policy issues. So I would support making clear that we leave them for another day and another recommendation.
Should I take that to mean, Don, that you support Paul's proposed language?
Yes.
Okay. I will say that my own sense is I agree that the substance of the issue is outside the scope of this particular recommendation. But I do think I took Ron's suggestion at least to be more in the vein of proposing a clear statement rule rather than weighing in on the substance of Court of Appeals versus district court. But on the other hand, I can see a lot of unintended consequences out of this. John Siegel, since you wrote the recommendations in the first place and are the consultant on this project, do you have a particular view on this?
Sure, thank you. I'm happy to weigh in on this. It seems to me there are two slightly different issues here. First, there's the issue which I took to be what Paul Kamenar said in his comment of just saying something that would call attention to the fact that if there's no statute saying otherwise, you file in district court so that people know that. So it would not recommend anything different. It would just call attention to what the law is. And then the other possible notion, which I think is more what Don Elliott was just talking about, would be to make a recommendation about where we think review ought to lie. So those are two slightly separate things. In the source book, I do have some thoughts along the lines of what Don Elliott just said, that on the whole, in review of administrative action, having review begin in district court is probably not the best use of judicial time, but sometimes it's justified, as for example, when there's such a large volume of a particular kind of case that it wouldn't be practical to send them all to a court of appeals. So in any event, I just call attention to the fact that these are two different issues. I did make some suggestions in the source book about it. They haven't appeared in the recommendation yet, because I think Matt and some others were of the view that that was too big a part to take on. It was out of proportion in its implications to the things that are in the recommendation. I certainly don't see any harm in adding, as the suggested language in footnote 5 would add, that we're not taking it on, just calling attention to the fact that we're not taking it on. Just one further thing I would just point out. If the point was simply to call attention to where you're supposed to file so that people don't inadvertently make a mistake, I think if anyone did inadvertently make a mistake, they would be saved by 28 U.S. Code 1631 in most cases, which specifically says where any civil action is filed in a court, including a petition for review of administrative action, but there's a want of jurisdiction, then the court, if it's in the interest of justice, shall transfer the action to a place where there is jurisdiction. So that would at least have the potential to save people who just inadvertently filed in the wrong court. Anyway, but summing up, I think it's correct not to take this on. And if we want to say expressly we're not taking it on, this proposed language would do it.
Don, it looks like you're raising your hand physically. So do you want to be heard again?
Yes, I just wanted to clarify my position. I have no problem with a clear statement rule. And I also don't even really have a problem if we're clear that we're simply describing what existing law is and cite to the cases that are involved. I just am concerned that we not try to take on the policy issues, and that we've been clear that we haven't taken them on, in part because if at some point in the future this gets reconsidered or ACUS wants to make a recommendation in that regard, I don't want whatever language is in ours to preclude that and say, oh, well, ACUS already looked at that previously. So I think we should be clear that we're not addressing the policy issues, which we would leave open for another day.
Jeff Lubbers, go ahead, please.
Thank you. I just wanted to point out that ACUS did address this way back in 75, recommendation 75.3, optimum forum for judicial review. I know it's old, but it's along the lines of what was just said by John, and I think maybe it should be referenced at some point, because it's a very concise and well thought out recommendation. I even give it to my students because it's pretty clear on the subject. So, I know maybe it could be revisited, but I don't see any big flaws in it.
John Duffy, please.
I do, if I may say, I do reference it in what I've said in the source book, but I didn't put it into the recommendation because, as I say, my understanding is we're not getting into that topic.
John Duffy, go ahead, please.
Thank you. The last sentence in this suggested footnote says this recommendation does not address when, where, and how such actions may be filed. I think that's overbroad, because we do address how these actions are filed. And we also have a suggestion about when. John identified some of those timing issues about some of the statutes that say before a certain date or on a certain date. So there are some components of this recommendation that clearly do cover those issues. If we're only worried about the where issue, we should limit that last sentence to the where issue. In other words, the district court versus court of appeals issue.
Matt Weiner, please.
I just wanted to say, apropos of especially Jeff's point, that as I think we discussed in December, and we've certainly discussed internally, ACUS would be, I think, very amenable, especially if, especially based on a recommendation from this committee, to revisit the recommendation that Jeff alluded to, which deals with the specification of the choice of court, district court versus court of appeals in particular. I think our thinking on that has been that we, however good John's source book is, we don't really have an adequate empirical basis to revisit that recommendation. But we're certainly very much open to, especially a suggestion from the committee that ACUS revisit that subject.
Okay. Does anybody else wish to be heard at the immediate moment? Not seeing anyone. So I think two things to be done here at the immediate moment. Number one, I would ask, ACUS staff, we do have meetings on occasion to decide additional projects to pursue going forward. So I would ask ACUS staff to keep track of the possibility of revisiting the recommendation from 1975 that Jeff Lubbers recommended, and this general issue with respect to venue as a possible future project that we can discuss at a future committee meeting. With respect to this particular recommendation, the proposal that we have on the floor is the language that is proposed to be added to the end of footnote 5. John Duffy has suggested that we amend this proposed language slightly to delete the words when and how, so it would just say that this recommendation does not address where such actions may be filed. Paul Kamenar, do you take that as a friendly amendment to your amendment?
Yeah, can you hear me?
Yeah, I can.
Yeah, no, I just want to clarify that. I know the recommendation does address the things, when, where, and how with respect to the statutory provisions where you say you have to file within 30 days or after 30 days, and we get into all of that and then and so forth. But when I say such actions, I was referring to, of course, to such actions where there's nothing in the statute whatsoever. So I'm not sure whether John's recommending misconstruing my last sentence there, but if he isn't, then I'm fine with that as a favorable amendment.
John Duffy, do you have further thoughts in light of what Paul had to say?
Well, I think as it's on the screen right now, I think that's better. I don't know where there's no statutory. I mean, it's
such actions.
Go ahead.
No, I just want to say it's the reference is such actions, meaning those where there's nothing said at all in the statute, and this recommendation doesn't even want to get into that, as Don Elliott was basically suggesting.
Right, but we are getting into some of the issues about how to file, right?
But I think only with respect to statutes that already say whether you do a petition for review, those kinds of format or formal.
Oh, I see. Okay.
Yeah. Is it a notice of appeal, a petition for review? That's how I interpreted how we're addressing it in the recommendation, the how part. The when, number of days, whether it's within 30 days, at 30 days, that kind of ambiguous language, and where is what we were talking about earlier, whether it's the district court or court of appeals. Jonathan Siegel's right that if you do file mistakenly in the court of appeals, they'll remand you in the interest of justice back to the district court, but you waste a lot of time doing that. Right. So I'm just putting this as sort of a disclaimer altogether. And if we want, maybe add at the end of that, Jeff Lubbers' point, we could say something like, see also, ACUS recommendation 75-3 or BUTC or something, if you want to alert the reader to that we had addressed it once before. I'm fine with it either way.
Bill Funk, your hand is up. Please go ahead.
I liked John Duffy's deletion of when and how, because referring to such actions. The action is actions under the APA. It's the sort of general part of the first sentence there. And we are talking about actions under the APA. We are making recommendations regarding how and when. So, I mean, the only way to keep Paul's stuff, I think, would be to add into his last sentence. The recommendation does not address when, where, how such actions may be filed, where the statute is silent on these issues. And that might make clear that his point on that regard, but I still just like John Duffy's solution as the simplest.
I guess I like my solution as a simplest too.
I mean, I guess the question then, Paul, is this an amendment that you're not willing to consider a friendly amendment such that we need to take a vote, or do you find this amendment acceptable so you're willing to accept it and we can simply move forward? I don't know that anybody has an objection to adding, these sentences to the footnote generally. It's just a question of how that last sentence is going to read, right?
Right. Yeah. No, I take these as friendly amendments. I don't care one way or the other. Maybe the Committee on Style might want to look at it, but I just want to make sure we convey to the reader that this recommendations deal only with provisions in the statute that expressly provides for judicial review. But sure, APA is a statute, but maybe when we say how such actions or how such non-statutory actions may be filed. But again, I don't think I'm concerned one way or the other getting into the weeds, but I'm amenable to whatever the committee and the chair wants to do on that. Sure.
I did not mention it before. I will make the observation that we have, as members of the committee received this information by email, we have tentatively scheduled a third committee meeting on this recommendation. I believe it was for May 3rd. It's possible that between now and then the Committee on Style can look at this. And if there are issues, then perhaps that, if they note an issue, then perhaps we can raise it at that third meeting. But in the meantime, unless I see an objection and unless I hear an objection, I think we're going to add Paul's language with John Duffy's suggested revision into footnote 5. Last chance for objection. Seeing none, let's move forward to the next broader issue that I think needs to be addressed. So several people really raised a similar comment. I'm going to start by mentioning, so public member Andy Vollmer submitted 2 comments. Andy, your second comment regarding recommending a place within the U.S. Code for the location of a new judicial review statute seems to correspond with recommendation 5. So I'd like to hold off discussing that suggestion until we address recommendation number 5 specifically. But your first suggestion was broader, that the committee might decide to do something further on the general federal statute of limitations in 28 USC section 2401. Rightly or wrongly, I'm grouping this comment together with a very helpful write-up from Special Counsel Jeff Lubbers, observing that courts often do not respect statutes of limitations like section 2401A, and also comments from John Duffy noting several issues with the language of 2401A, and comments from both John and Dick Pierce recognizing the Supreme Court's decision in PDR Network LLC versus Carlton & Harris Chiropractic in 2019, which somewhat addressed this issue with respect to the Hobbs Act, but also sort of dodged part of the issue as well. Ron Levin has raised an objection to taking up this issue at this time. So with this, I'm opening the floor to discussion of section 2401, and issues relating to it as to whether or not we should address them. I believe that, there may be a sense that this is beyond these issues are beyond the scope of this project, but I welcome comments for or against that proposition. Matt, I know at one point you had expressed some views about pre versus post enforcement review in conjunction with 2401.
Just a general comment here, and maybe I can put Bobby on the spot or Reeve. My recollection is that at the, I don't want to say the issue of pre-enforcement review is I don't want to say definitively that's beyond the scope of the project. The project refers to technical issues. The project proposal the project description refers to technical issues. That's really up to the committee to interpret. There was discussion though when there was discussion at the December meeting of the committee that formed the basis for this project. There was discussion about the issue of provisions for, and I'm just reading from the memo at the time to the committee, provisions for judicial review in the context of enforcement proceedings. And I think it was generally understood at the time that issues relating to that would not be something that the committee would take up in the context of this particular project. I don't know if Reeve or Bobby wants to elaborate on the discussion that was had at the committee meeting, the particulars of which I just don't recall sitting here right now.
John Siegel, your hand is up in this regard.
Thank you. You know, I looked at these comments, and I looked at some of the comments that Ron Levin provided on the source book, which I was working through just earlier this week. And you know, two comments. First, it's not quite clear to me what people want done about 2401. I mean, Jeff Lubbers says it refers to the problem that courts do not completely honor the time limitations on pre-enforcement review. I'm not sure I agree that it is a problem, since I'm generally in favor of broad availability of judicial review. So, you know, putting it all together, I think I agree with Ron Levin to the extent that he suggests that it would be not a great idea to try to work that into this recommendation. So that would be what I would agree with.
Let's see, I have Jeff Lubbers next, please.
Thanks. I normally defer to Ron on these matters, but I wasn't really raising the general statute of limitations issues. I was just trying to raise the issue with respect to these special statutory provisions, mostly in environmental statutes, that try to channel judicial review into the pre-enforcement stage. And if you miss the deadline, you give up the right to challenge the rule at the enforcement stage. And the statutes are written in such a definitive way that a litigant might say, oh, if I miss this deadline, I'm completely out of luck. I'll never be able to challenge again. And that's not the way the courts have read these provisions. They've allowed challenges such as constitutional challenges, sometimes ultra-virus challenges, criminal defense challenges. So I think the statutes are misleading. And since ACUS back in 82 made some specific recommendations about, you know, when Congress decides to limit the availability of judicial review of rules at the enforcement stage, it should ordinarily preclude review only of certain issues. And so there's some specific suggestions in there. And it just struck me that this is consistent with what this project is trying to do. Now, maybe it's too big of an issue, or maybe my part of it is too narrow of an issue, but it seems like it's consistent with what we're trying to do here.
Alan Morrison, please.
I agree that we should not discuss this issue at this time. The committee, John's report does not discuss it. It's very difficult and controversial as to how it ought to be done. I wouldn't be bound by what the December meeting of the planning committee thought, whether that's legislative history or anything else. If it's important and we could deal with it sensibly, I would deal with it. But I certainly agree that this topic, as well as the topic about district court versus court of appeals, is not within our purview at this time for many of these reasons. Thank you.
Just to be clear, Alan, I wasn't suggesting that the legislative history from the December meeting forecloses consideration of this issue. Okay. Maybe I should have been more specific, but there was discussion at the December meeting along the lines of exactly what was said now, which is that we really don't have a basis in a report, in this case, John's source book, yes, for addressing this issue. And here again, I would certainly invite the committee, if it thinks that this is an issue that ACUS should take up in a successor project, to say so, either in the context of this committee meeting or, as Kristen suggested earlier, a subsequent committee meeting.
I have Don Elliott and John Duffy in the queue, and so I would like to recognize them. However, I will say at a minimum that anything that comes up in this meeting as, as we're having this discussion of broader issues that we decide not to address with respect to this recommendation, I would ask ACUS staff to keep track of these things so that potentially at a future planning meeting, we might be able to take them up as additional projects. But let me recognize John Duffy and then Don Elliott. Jeff Lubbers, I can't tell if your hand is still up from before or if you meant to take it down. John Duffy, go ahead. Or no, sorry, Don Elliott, then John Duffy. Don, go ahead, please.
Yes, I just wanted to say I agree with Alan Morrison that this is an important and complicated issue, but not something that we should be prepared to take up at this time. I do think I disagree a little bit with my friend Jeff Lubbers. I think the questions in the environmental area have been quite complicated, and the court decisions are not really uniform, in part because the government is making and sometimes winning very broad arguments precluding judicial review. So I think it's a highly important topic, but I think it's one that deserves a report and a full examination, and not something that we should make recommendations about on the fly.
John Duffy?
I think I'm in agreement with Don Elliott. I look back at my original December 3rd comment, which raised both these issues, which is the statute of limitations issue and then the PDR issue. With respect to the PDR issue, I expressly noted that it might be outside the scope of this project. It might be actually helpful to, just like the footnote that we drafted or that we approved in the project, to say we're not, taking up certain issues. So maybe we can add some small language to that footnote. Having just narrowed that footnote, I might ask to expand it, but we're still sort of, we are still saying some things about when, but we're not saying that much about when. So we have to, maybe we should include some language that say that it's really a statute of limitations issue and then these preclusion issues, which I do think are complex, and I would certainly support a project on that. Thank you.
So John, how about we do this? John, can I task you with coming up with draft language to add to the preamble to reflect this point? And then when we get to the preamble, perhaps we can discuss that draft language. But otherwise, I will just ask the staff, the ACUS staff, to to jot down these ideas for potential future projects.
Is that John Me or John Siegel?
That's you, John Duffy.
Okay, yeah, okay, sure. If I get a task from the chair, I will do it. I just want to make sure I'm the right job.
I would appreciate it. Yes, although I'm sure John Siegel behind the scenes would be happy to weigh in, but if somebody could work on some draft language for the preamble to this effect, then I think we can consider it at that when we get to the preamble, and that will be helpful. Otherwise, are there any further thoughts about this particular sort of collection of issues, if you will?
Kristen, just one more point apropos of future projects. The third issue, I think, that we sort of bracketed back in December and that we never considered part of this project was the subject of issue exhaustion. And that's another issue that the staff will look into. And I understand that the Supreme Court just issued a decision in the issue exhaustion case involving the Social Security Administration, but I haven't read that yet. But that is on our list too. And I just want the committee to be aware of that.
Excellent. Yes, I would note for the committee in that regard that the Supreme Court did issue the opinion in Carr versus Saul this morning. I haven't had a chance to read it either beyond the syllabus, but I can report that the Supreme Court held that issue exhaustion was not required in the case. And to the extent we're going to take up issue exhaustion potentially at a future date, we certainly would need to take that opinion into account one way or another. Okay. Last but not least, I think with respect to the broader comments, we did also receive thoughtful comments from a member of the public, Elaine Middleman. I want to thank Ms. Middleman for taking the time to submit comments to the committee. I do think it's important for us to recognize that ACUS's jurisdiction with respect to the judicial review function is somewhat limited by ACUS's role as an executive branch agency and not as part of the judicial branch. And after consulting with ACUS staff, it's my judgment as chair that the comments from Ms. Middleman are not germane to the proposal before us and fall outside the jurisdiction of this committee to act. But I did at least want to recognize Ms. Middleman's comments and thank her for her contributions. With that, I believe that we are done with the collection of broader general proposals that do not relate to specific line items or recommendations within the document that was circulated on the 19th. If any of you think that I am mistaken in this regard, please raise your hand and let me know. Okay, seeing no raised hands, we have been going for not quite an hour, but it seems to me like a good, it's getting close to an hour. So it seems to me that this would be a good time for a 5-minute break after which we will come back and we will turn to specific recommendations. Just wait, I'll just wait to see people turning on their cameras to know that people are with us. Thank you, Bobby, for pulling back up the document. Okay, we're going to turn next to the recommendations themselves. Since this document was circulated on the 19th of April, there have been a few proposed adjustments that we need to go through, and there were a few items that were left over from last meeting as we sort of wanted to see how everything looked once we got it formatted into the proper document form. I know that in addition to sending the document out on the 19th, it's posted on the ACUS webpage. And Bobby did post the link to the document in the chat feature. So if you're having difficulty finding it, you can find it there. So starting with the heading for the first set of recommendations, general drafting recommendations to Congress. I know Jeff Lubbers had to leave the meeting, but Jeff did send in suggestion that this be amended to recommendations to Congress when drafting or amending judicial review provisions, or something like that in order to provide additional clarity. Bobby, I don't know if you can type in that proposed adjustment. Recommendations to Congress when drafting or amending judicial review provisions. Comments or concerns about this proposal? Jeff Siegel, go ahead, please. John Siegel, go ahead, please. John, we can't hear you. You need to unmute yourself. You look like you are unmuted.
How's this? Can you hear me now?
That's much better. Thank you.
I like this one. I think it's clearer than the heading I chose. If I could just say generally, since the last meeting, as you know, at the last meeting, it was decided that we wanted a preamble, and it was suggested that we split the recommendations, reorganize them into the drafting recommendations versus a new statute recommendation. So I did that. And I also tried to implement the decisions of the committee at the last meeting. Sometimes I felt like we hadn't quite reached a decision, so I apologize if I didn't implement anything correctly. But in any event, I like this proposed change.
Alan Morrison, go ahead, please.
In the interest of brevity, I would suggest we strike or amending. Otherwise, we have to put repealing and everything else in there. It seems to be perfectly clear when they're drafting it.
Well, I don't know that we need to include or repealing, because if you're repealing, you don't worry about the language.
No, but I mean, but the repealing part of it, I mean, I just think we could strike or amending, but I don't care.
John Siegel, do you have since Jeff Lubbers isn't here, but John Siegel, you approve of the amendment. What do you think?
I guess I agree that or amending is not necessary, and it reads slightly better without it. So I think I would agree with Alan on that. I mean, I don't think it's bad to have it in, but I think it is incrementally better without it.
Does anyone have an objection? Let's put it this way. Does anyone have an objection to either replacing the original heading with recommendations to Congress when drafting judicial review provisions, or does anyone have an objection to deleting the words "as amending" from Jeff Lubbers' original suggestion? Hearing no objections, we'll take what's on the slide. Thank you very much, everyone. Okay, I do not have any proposed amendments at present to recommendation number 1. But, you know, and I will say that we did a pretty good job in the last meeting, I think, of going through and addressing a variety of different concerns, but recognizing, as John Siegel suggests, that, you know, we didn't have these in our traditional form at the time that we considered the recommendations at our last meeting. I feel that I do need to give people the opportunity to raise any concerns about item 1 before we move on. John Siegel, I don't know if your hand is up from before or if it's new.
Sorry, that's from before. Let me lower it.
Okay. Any concerns? Seeing none, let's move on to recommendation number 2. Here we do have a suggestion. We have a couple of issues. I'm going to take a comment that was submitted by Jeff Lubbers first, and then we'll move to the staff comment. Jeff Lubbers submitted the suggestion that in line 118, where it says Congress should provide that the time starts from the publication date for the regulation. He found the use of the word "from" there to be confusing, and suggested that we substitute "on," that the time starts on the publication date instead of from the publication date. John Siegel, I don't know if you think that that changes the meaning,
well,
or if anyone else has any concerns about this proposed change.
Thank you, Kristen. There is a little danger there in that typically whatever event is the event that starts a time running, the typical way of the time is computed is that that day is effectively day 0, and the first day is the day after that event. So if the difficulty is the ambiguity is the word "from," perhaps it would be better to just rewrite the sentence along the lines of something like, where the event is the promulgation of a rule, Congress should provide that the rule is considered to be promulgated on the day it is published in the Federal Register. So that what makes clear is that we're just advising as to what the event is, and the question of whether that's day 0 or day 1, that should be taken care of by other language in whatever statute Congress is drafting in accordance with recommendation 1.
let me ask this question of the committee. You know, and this is with total respect for Jeff Lubbers, who makes tremendous contributions to these things. Does anyone else find the use of the word "from" in this context confusing, such that we ought to revisit how this sentence is worded more broadly? Or is that particular source of confusion unique to Jeff? Bill Funk, go ahead, please.
I did not find it confusing, and I found Jeff's solution to be wrong in the same way that John Siegel explained that it's 0 day, not the first day. So I think Jeff's solution would be the wrong solution to a problem that I don't think exists.
Thank you, Bill. I appreciate that. Any other thoughts? I mean, my own view is I was with Bill and John Siegel. I didn't find the use of the word "from" confusing, and I take John's point about "on" being different from "from." But at the same time, I want to give, full, especially since Jeff isn't here, I want to give full opportunity for someone to weigh in otherwise. Okay. I'm not seeing anyone jumping to defend Jeff's proposal, so I think we will consider it rejected and we will move on. So the staff comment, we see bracketed language here from our April 1st committee meeting. And I don't remember whether we resolved this or not, and I take it that John was confused as well. So consequently, we have, the sentence currently reads, the second sentence of this recommendation would currently read, where the event is the promulgation of a rule, Congress should provide that the time starts from the publication date for the regulation in the printed version of the Federal Register, ... We'll come to the second bracketed language later. The, question before us at first is whether we want to refer to the, instead of the promulgation of a rule, the issuance or the adoption of the rule. Thoughts on this? I don't remember who originally raised concerns about the use of the word promulgation. John Siegel, maybe you remember more than I do in this regard. But Alan Morrison, your hand is up. Go ahead, please.
I would recommend that we not include the various items in the brackets and that we explain in the preamble that what we mean by those terms, that we have used the issue of promulgation, meaning this, and so, and the Federal Register means this and so that way. We're not writing a statute here, and each of these statutes is written differently, and I think our point is very clear. And regard the details, I don't care which word we use, but I think that we don't need to encumber it with a lot of lawyer-like language that you find in a bond indenture. Thank you.
I will say it does appear that the preamble uses a broader variety of terms in this regard. So I will simply make that note. And then I will call on Don Elliott and then Allison Ziva.
I think it should say promulgation or revision of a rule. That is existing language in Section 307D of the Clean Air Act, which is sometimes called the Little APA, and it has been interpreted numerous times by the courts, and they don't seem to have any problem with it. That would be my suggestion as to how to resolve this issue. I like promulgation, but promulgation does have the unfortunate connotation of simply being the initial promulgation of a rule. So I think the language is completely unambiguous and clear if we say promulgation or revision of a rule.
I don't have any problem with that.
Allison?
So I just wanted to confess to being the person who suggested we not use the word promulgation. To me, it's just such a lawyer word, although I confess I use it sometimes, but if it's a synonym for issuance, that's just a word people use and understand better, I think, than promulgation. But anyway, it's more a confession than a...
Well, we welcome your input. We welcome your input, certainly. So no need to be sheepish about it. You know, preferences for promulgation versus issuance or adoption. We got to pick one. Don, Elliot, go ahead.
The problem I have with the word issuance is I think it supports the idea that the government has sometimes argued that the times begin to run when the rule is issued or and appears on the website, even in advance of its appearance in the Federal Register. I do agree that promulgation or revision is a lawyerly term. It's a term of art. But I think most of the people that will be reading these recommendations are either lawyers or people who have a good legal understanding. So I think unless we want to change things, we should stick with a phrase that is a term of art and has a well understood and established meaning. Otherwise, if we use something different, then I think we're inviting ambiguity and litigation about what it means. So I continue to think promulgation or revision, which is an established term in 307D of the Clean Air Act, would be the way to go.
Bobby, if you wouldn't mind, just so we don't lose track of it, if you could please add, or revision, including amendment or repeal, there you go. Thank you. Just because I don't want to lose track of that. I will make the observation, Don, in response to the point you just made. It is true, though, that the rest of the sentence then goes on to say Congress should provide that the time starts from the publication date for the regulation in the printed version of the Federal Register. So almost irrespective of what word we happen to choose to use, we will end up recommending that that's when the time would start, when it gets published in the written version of the printed version of the Federal Register. That said, I've never had a problem with promulgation, even if it is a bit lawyerly. So Bill Funk is next to be followed by Andy Vollmer.
I have a question as to whether or not a repeal is a revision. If we're going to be specific about not just initial promulgation, but also revisions, shouldn't we also be specific as to repeal and say promulgation, revision, or repeal?
Andy, go ahead, please.
I was going to address a couple other issues, so
okay.
maybe you should finish up with.
Why don't we come back to you then? Thank you. I will make one more observation here. The language that is used in the APA, for issuance, it uses the word formulating, and I don't think we want to use that. But the APA definition of rulemaking uses the words amending and then repealing. So to the extent we're wanting, not to be overly lawyerly about it, but to the extent that we're trying to capture a concept, perhaps rather than, I take the point that revision is what is used in the environmental or in the EPA context, but to the extent that we're speaking to more than one agent, with respect to more than one agency here, perhaps the APA's terminology about amending or repealing is the right language to use. I'll just throw that out there as a possibility. Don, go ahead.
I think that's a good suggestion, Kristen, and I certainly would be happy with a friendly amendment that said promulgation, amendment or repeal. So I think to make it parallel, they should all be nouns. promulgation, amendment, or repeal. That would be fine with me. I think that's quite clear. And I take your point that tracking the APA language is probably better than tracking the language of a particular environmental statute.
Allison, can you live with promulgation?
I have lived with it for many years. I can continue.
Okay, let's keep it as promulgation, amendment, or repeal of a rule. Now, Andy, would you like to raise your separate issue?
Yes, thank you. But I'm going to actually now raise something about all that stuff. What about using more general language where the event is action on a rule? Anyway, so if anybody likes that, rather than the long string. But that's not why I wanted to talk. And I'm going to make a couple smallish points so I don't have to come in, sorry, on separate occasions. First point is, why is this recommendation limited to regulations or rules? Why doesn't it also apply to orders? Second, we're coming up to this language, but I'm getting my thoughts out early. I think printed is ambiguous. It's not helpful because the website for the Federal Register, which I have open, it's got all kinds of different forms for notifications in the Federal Register. It's got a PDF, and we know there's a paper version that comes out, and then there's this new electronic thing that you can see. Anyway, they're all printed, so I don't like that. And then I really don't like the date being the latest date. I just think that creates opportunities for confusion. Like on the main site for a notification, which I have open, it's a consumer financial protection thing. It's got a bunch of different dates on the electronic form. And I don't know what that language would mean for the printed version, the paper version. It could be the effective date, the comment. I mean, they're just a bunch of dates. So I don't think there's ambiguity about the publication date. The site, the Federal Register site, has a caption, publication date. And if you click the PDF, the publication date is identical to the date in the header for the Federal Register. So I believe that would be the paper version date. So those are my couple little points. Anyway, I'm trying to become simpler and clearer and avoid possible complications, which I think we all are trying to do.
Thank you, Andy. Somebody remind me, but my recollection is that in our last meeting, we actually spent an extensive amount of time sorting through the various different electronic and print forms of the Federal Register to try to figure out what the appropriate date was, because there was confusion about the possibility of there being different dates of something appearing in the electronic version on the web page versus the listed publication date in the document itself versus the date at the top of the Federal Register page. I may be misremembering that conversation, but that is my recollection. I don't know, Bobby, whether you can help us out here, or John, if you have, John Siegel, if you have kept better track than I have, but we may as well clear that off at the moment. We got to deal with something else first. So let's take care of that. What did we talk about then? John Siegel, go ahead, please.
I think you're right, Kristen, that at the last meeting, we had a long discussion of what exactly constituted the publication date. In my respectful opinion, I am of the same view as Andy Vollmer just expressed, that I think publication date is fine, and that I think we just twisted ourselves into knots somewhat unnecessarily at the last meeting. I mean, the main point of this recommendation was to distinguish between the date on which the agency internally approves a rule and the later date, in some cases, on which that rule is published in the Federal Register. That's the main point. Then, as I said, and as you said, at the last meeting, we got into this big discussion of what exactly is the publication date. I have to say, I had previously sent an inquiry to the ACUS member from the Federal Register about, you know, what the definition of publication date is. And let me just read you the first sentence of her reply. She said, "Good morning, John. I am unaware of any uncertainty around the date of publication in the Federal Register." She says, "This seems like such a basic question that I feel I'm missing something." But, you know, her opinion was publication date is unambiguous. And I think we just got ourselves unnecessarily worked up trying to define that more precisely, and ended up with a lot of words that I agree with Andy are probably just more detracting than helpful. So I would just say the date of publication in the Federal Register. And then the business about the last date, as I recall, that was to deal with a situation where a rule is promulgated in separate parts over time. I've never seen that. I mean, maybe that happens, but I've never seen that happen.
You know, I will say, I know that at least, you know, the agency I'm most familiar with, the IRS, frequently puts things on its website, you know, at different times, or in its documents at different times than things get published in the Federal Register. But I guess it's an empirical question that maybe you or somebody else pinned down, whether, you know, to the extent, you know, Andy's point, I think, about the printed version, you know, there is an electronic version. I don't even know if the Federal Register still puts out actual physical books. But, you know, I guess as an empirical matter, is it possible that you could end up having different dates in different versions? Or is publication date such a clear term that people who really know what they're doing know what that term means?
Kristen, if I may here,
yes,
I agree with John 100% and Andy, and also our representative from the Federal Register. I think the unadorned phrase publication date appears in all sorts of legal materials, including executive orders. It appeared in the Chief of Staff's memo about what the incoming administration should do about new regulations, regulations promulgated under the Trump administration. I don't see any ambiguity with that phrase, but and I think we probably ought to give some deference to the Federal Register folks on this.
Sure. Judge Moss, I understand you would like to weigh into this discussion. Please go ahead.
I just wanted to say, I have a recollection that there was a very old OLC opinion prior to electronic media that said that the publication date was the date that the Federal Register actually publishes the rule, and not the date in which it is, in some sense, published for viewing. It used to be, I don't know if you can still do this, where you could actually go down to the Federal Register and see a version of the rule before it actually appeared in the published text. I think there is an old OLC opinion that addressed that question and said it was the date of the actual printed publication.
So, Judge Moss, just for clarification, does that mean that you think that there is a problem with the language as it is presently worded without the material that's in brackets, or do you think that the language is okay?
I think the language is okay.
Okay. I'm hearing a consensus generally that the language from the publication date for the regulation in the printed version of the Federal Register is sufficiently clear that it doesn't need further elaboration. Before we make that the final language, are there any objections? Go ahead, Andy.
I just wanted to remind you, if anyone wants to consider my point about why is this limited just to rules?
Yeah, I haven't got, that's next on my list.
Thank you.
Right now, we're just dealing with the publication date issue and the printed version issue. Don Elliott, go ahead, please.
Thank you. I think we should, just to be clear, say promulgation, amendment, or repeal of a provision of a rule. My concern is that rules are not always, they don't, of the provision being challenged, because you sometimes have a situation in which, you know, the rule is promulgated on one date, and then there's a revision of a portion of it on a different date, and the time should run from the time that the provision being challenged gets into the rule.
Michael Hertz, go ahead, please.
So I think that makes sense. I had a couple of quick points. One was, I think the answer to Andy's question about order is the first sentence clearly applies to orders, but the rest of this paragraph is about things that get published in the Federal Register and orders don't. With regard to that, it says in line 118 there, provision of a rule, and then it says date for the regulation in 119. It seems to me one should just be consistent and say rule throughout this rather than switching from rule to regulation. Then third was in 118, rather than the publication date for the rule, I would say the publication date of the rule. Publication for the rule sounds like it's some predetermined date or something. It just means the publication date of. And then the last thing, which circles back to what we were actually discussing, I had thought when the whole business about are we over complexifying this came up, that also on the table was eliminating the reference to the printed version, just refer to the publication date in the Federal Register, which I think, as everyone has already said, is the language that's used and is clear. I believe the Federal Register does still appear in print. I think it's a statutory requirement, but at some point that will go. And there will no longer be a printed version, but we still will know what the publication date is. As Andy said, the PDF is up, whether it exists in hard copy or not. There will be a date for the publication for each issue of the Federal Register. So I would suggest getting rid of the printed version of.
Thank you, Michael. So I will make one observation with respect to orders versus rules. It is true in my recollection anyway, I'm not a Federal Communications Commission expert, but my recollection is that the Federal Communications Commission often publishes regulations under the label of order. I don't know if that makes a difference here.
It's a rule for purposes of the APA, even though they weirdly call it an order.
Right. No, I get that. I get that. And the Supreme Court has basically, you know, I've seen cases in which the Supreme Court has said it looks like a rule and it was promulgated like a rule. So we're going to treat it like a rule, even though it was called an order. You know, so, you know, I don't know that that necessarily matters, but I don't think it's quite fair to say that, you know, that the second sentence doesn't apply at all to orders. It's just a question of whether it's how you deal with that terminological difference. And I don't have a good answer for that. You know, Bill, you're next in the queue.
This is not in response to your problem, which I don't think is a problem. I think, again, let's refer to the APA, at least in our minds. And my point was to say, I don't think we should say provision of a rule, because if you adopt a revision of a rule for just make one provision change, that is a revision of a rule. That is a rule itself. So that, especially when we then refer back to provide the date for the publication date of the rule. Well, do you mean of the provision of the rule, or do you mean of the original rule? So the provision of a rule just, I think, makes it very unclear, and just leave it good old-fashioned APA, promulgation, amendment, or repeal of a rule, because even publishing a provision of a rule is itself a rule.
Okay, next in the queue on this, I assume it's relating to this issue, is Andy Vollmer.
Well, I'm not sure what this is anymore, but so I just didn't understand. I don't pretend to be an expert about all the different things the Federal Register publishes or doesn't publish. But I do know the Federal Register publishes orders, and I mean, my area is the securities laws. So there are SEC orders published in the Federal Register all the time. And my concern was that we started recommendation 2 with a pretty general sentence, and then we limited it with rule, and I didn't know whether that was meant to exclude other forms of agency action that could be reviewed other than a rule. And I know people challenge SEC orders, and I know the securities laws, in fact, treat orders and rules differently for purposes of judicial review. So that was the origin of my question. And I just would hate for somebody to read our recommendation as being limited to rules and not touch orders.
I don't read it that way at all, Andy. I mean, I read the first sentence as being the recommendation, and then the second sentence as being sort of elaborating in the circumstances where we're talking about a rule. But event is very clearly, I think, from this language, broader than rules, because that's why we use the word event in the first sentence. I don't know if other people would disagree with that. I will add that I think Bill's right with respect to provision of a rule, that it should just be rule, especially since we say promulgation, amendment, or a repeal. That does track the language of the APA. But my recollection is Don Elliott made that proposal to begin with, and Don is next in my queue. So I'm going to call on Don to address whatever of this he wants to address.
Thank you. I agree with you and Bill. My suggestion of provision was actually to put it in a different place. So I think the provision got added in the wrong place. My intention was that it would say promulgation or amendment, promulgation, amendment, or repeal of a rule. Congress should provide that the time starts from the publication date of the provision in question in the Federal Register. I don't really care about that, but I mean, I agree with Bill. The way we had it before actually introduced an unintended ambiguity because of where it was placed. But I don't really care. I just thought provision in question would be clarifying. But I would agree with you and Bill, it's not really necessary. And it was clearly problematic where it was previously inserted.
Further thoughts on this? I think my inclination would be to keep it simple with rule, as sufficiently clear, particularly in the context of the Administrative Procedure Act.
That's fine with me. Let's just move on.
Okay. So we're going to leave that as rule. We're going to get rid of provision. So this is going to read, this second sentence is simply going to read, where the event is the promulgation, amendment, or repeal of a rule, Congress should provide that the time starts from the publication date of the rule in the Federal Register, period. Is that consistent with everyone's understanding? Objections? Okay, let's move on to recommendation 3. We do not have any amendments proposed with respect to recommendation 3, but I do see Alan Morrison's hand. So let me call on Alan.
Thank you. I want to refer to recommendation 4 because it uses the word complaint in recommendation 4, and I think the complaint should be in recommendation 3 as well. Because we do know that Social Security is obviously an example, but that's already in the statute, but others may be as well. And so I think just to be clear that we want them to be what should be filed by petition for review or complaint.
Do you think it should be just or complaint, or do you think it should be consistent with the language in 4 so that it would say petition for review, complaint, or other document initiating judicial proceedings? Well,
I suppose one way to make them parallel is to strike the or other document initiating judicial proceeding, because I think we have as far as I know, complaints, judicial petitions for review, and notices of appeal. This is the idea, to take out notice of appeal. So I don't think we have to introduce, somebody would say to me, what are these other documents? And I don't know what other documents would be. If somebody knows one, then maybe we should say it. But that's why so I haven't made a motion. I wouldn't necessarily including that, but it's obviously better to make the parallel and to eliminate unnecessary language. Thank you.
John Siegel is our original drafter. Do you have thoughts in this regard?
Yes, thank you. I mean, the point of 3 was to recommend that Congress uniformly provide that review of agency action be initiated by something called a petition for review. Now, Alan is correct. We were most specifically thinking as opposed to notice of appeal. But what I took, I mean, this really was initiated by Professor Duffy, so maybe you should call on him next. But I took his suggestion to be, let's regularize this and say, use the term petition for review in all cases. Whereas in 4, I think the reason we have some alternatives in 4 is it recognizes that, we're recommending 3, but it's not likely to be instantly implemented. So for at least some period of time, there will be other forms of documents used to initiate judicial review. And in 4, we're saying whatever the document is, it's better not to specify its content, but to let that be dealt with by the applicable rules of court. So I think they are directed at slightly different things that would explain why the language is not parallel. I'm just thinking of what Alan said. I mean, do you file a petition for review in district court to initiate review? I think that is our recommendation, that should uniformly be used. So I think they are appropriately different.
So does that mean you would strike out or complaint, or do you think it would be, do you want to keep, are we just talking about or other document initiating judicial proceedings?
In 3 or 4?
Well, in 3 and 4, because we're kind of talking about them together.
Well, again, I think the point of 3 is to suggest that Congress always call for a petition for review. So I think 3 should just say that, whereas 4 recognizes that Congress is not instantly going to implement 3, and therefore 4 says whatever the document is called, don't specify its content.
Got it. Okay. So let me ask, because you said this originated with John Duffy, let me invite John Duffy to get into the queue, but I also have Alan Morrison and Bill Funk. So let me start with Alan.
John may ultimately be right, but the current reality is that many of these cases are going to end up in the district court. And if they are in the district courts don't get the rules, the federal rules of civil procedure provide for filing a complaint. One way to take care of this is to recognize the non-parallel nature of 3 and 4 is by filing a petition for review rather than a notice of appeal. And then we don't have to worry about 4 because we recognize, as John said, we're dealing with a discrete problem here, and no one will think that it means to say that they should not file a complaint because it just isn't having to do with that. John, would that be okay with you?
I'm sorry, I lost the thread of that right at the
I think
I would say
the proposal is rather than a notice of appeal.
Oh, I see. Yes, that's fine with me.
Okay, then we don't need complaint in there because it doesn't come into the universe there.
Okay, so next I've got Bill Funk, please.
I like the suggestion that Alan just made, but I think in number 4, we should just delete petition for review, complaint, and just have it, not specify the required content of the document, not other, takes other out as well. Content of the document initiating judicial proceedings. I mean, we don't need to specify what the title of the document is. And then we avoid the sort of problems of what it's called.
I'm seeing John Siegel nodding. Okay, next in my queue, I've got Don Elliott and then John Duffy.
I agreed with Alan Morrison's point about the provisions of Rule 3 of the Federal Rules of Civil Procedure that a case in the district court is initiated with a document called a complaint. I'm not sure that I agree that the language rather than a notice of appeal solves the problem. If Congress were to provide that an action to review administrative action, which was to be filed in the district court, was initiated by a petition for review, I think that could create some problems because the Federal Rules of Civil Procedure says that the document initiating a case in the district court is a complaint. So I think it should say initiated by filing a petition for review, it should say filing a petition for review or a complaint rather than a notice of appeal. Because it's still going to be a complaint if it's filed in the district court.
I don't have any problem with that.
John Siegel?
I'm just looking back at my source book research to see whether it is correct that judicial review, if initiated in a district court, must be initiated by a complaint as opposed to a petition for review. I'd like to research that before.
Let me let you do that while I call on John Duffy.
Yes, I think the change to 3, at least with saying rather than a notice of appeal, is right. This recommendation was always designed to sort of steer Congress away from a notice of appeal, and that practice has bad implications. So I'm okay with either the petition review or a complaint. I think that's fine. But the main thing is to steer Congress away from the notice of appeal. On 4, I think also the amendment to just say the document initiating judicial proceedings, that seems fine. It's the sort of larger set, the larger genus of things that we're talking about.
Sure, and let me raise one other issue or one other question in this regard, and I'm agnostic here, I genuinely just don't know, but to the extent that we have petition for review in quotes, should we have complaint and notice of appeal in quotes, or is that overkill? I will leave to others as to whether that makes sense or not, because again, I'm agnostic and I genuinely don't know. Alan Morrison, I'm not sure if your hand is up from before or if you have another point that you want to add to the discussion.
I failed to take it down.
Okay. I'm just having trouble keeping track. I apologize for my inability to do that. Michael Hertz and then Allison Ziva.
So I would have thought that if Congress passes a statute saying the piece of paper gets labeled petition for review, that trumps the rules of civil procedure. But John is going to research that and we'll figure it out. If the conclusion is that we are only talking about actions in courts of appeals, then one could say, you know, when drafting a specific judicial review statute providing for review in a court of appeals, comma, Congress should provide that it's initiated by filing a petition for review, period. And that solves the complaint issue. And this thing about rather than a notice of appeal is an odd, you know, it feels a lot cleaner.
Allison, go ahead, please. And then Judge Moss.
My comment's very similar to that one. If we are just talking about filings that go directly to the Court of Appeals, we should say that in the first part of the sentence and end the sentence after review. I don't think quotation marks are necessary, but I don't think that's important either way. But if we don't change the beginning of the sentence, then we absolutely should include or a complaint. I just think it would be really confusing for people filing in the district court, which is where judicial review very commonly happens, to start filing things called petitions for review. I don't know what the clerk's office will do with that, or people just be confused and not know what to file. Also, the rest of the rules of civil procedure, you know, you answer or the government answers 60 days after the filing of the complaint. I don't know what they do in the district court after the filing of a petition for review because the rules of civil procedure don't address it. And as for number 4, I wanted to agree with the comment before Michael Hertz's comment about 3, that one should just be simple. And I think last time we discussed for a while that we did want to specify in 4 why they shouldn't specify the required content, but I don't really think that's necessary to put in the recommendation and would fit well in a preamble, or they can look back at John's book, but it seems sort of clumsy to have it in the recommendation. Thank you.
Okay, we will come to the bracketed language in 4 in just a moment. Let's focus on resolving this issue with respect to 3 first. Judge Moss, I have you next in my queue.
Oh, thank you. I may be beating a dead horse at this point, but I very much agree with Don Elliott's comments with respect to adding or a complaint. I have never seen a filing in the district court that has been labeled as a petition for review, and if I saw one, I would think it was very odd. I don't know how our clerk's office would react to it. I agree with Alice and Zeev that we create issues under the federal rules of civil procedure and how one counts days. And also, I'll add to that it's not infrequent that people bring cases in the district court that are challenges to administrative action and are seeking review of administrative action. And that is one count of a complaint. And the complaint may include other counts that are not seeking review in this sense of administrative action. And we then contemplate filing 2 documents, or a document that is a complaint and a petition for review, and where the timing may differ for the two. So I think it would inject a great deal of confusion if Congress were to start referring to filings in the district court as petitions for review. So I would urge adding the language that Don Elliott has suggested.
Okay, so we have several suggestions here, I think, to revise the language of 3 to begin when, and it's in the chat, Bobby, but to begin item 3 as when providing for review in a court of appeals, comma, Congress should provide.
I think since that language is mine, I probably, if people like the when drafting a specific judicial review statute, that should stay. That's setting the context. And then Congress.
So then put in when providing for review in a court of appeals.
Right. When providing, exactly. Yeah.
Maybe we should change when to in so that we don't have 2 clauses beginning with when.
Or we leave it to the committee of style. I mean, it's the kind of drafting that goes badly, done on the fly, but.
Yeah, no, I get it. But, you know, in any event, okay, at which point then we would delete or a complaint. Would we also delete?
Just end the sentence after review.
Yeah, so just say by filing a petition for review, and we delete all the other. Bobby, why don't you just draw a line from that rather than getting rid of it altogether so that we can see what we're doing here. Thank you.
But the quotation marks do some work there. That's it, so they should stay.
Yes, we need the quotation marks. Okay, Allison, your hand is up. I'm not sure if it's up from before or whether you have something new to say.
Sorry, it was up from before, but as long as it was up, maybe the first part can just be when drafting a statute providing for judicial review in the Court of Appeals.
That would be simpler. Michael, are you okay with that?
I'm totally fine with it. I just, you know, having not been at the last meeting and not involved in this, I was trying to leave as much intact as possible, but I'm not wed to it at all.
So Bobby, that would be when drafting a statute providing for review in a court of appeals. Okay, there we go. Now I have John Duffy to be followed by Don Elliott.
Michael Hertz is wants to cut that last rather than a notice of appeal. I just think it's better to have.
We did. It's
I know, no, but I don't like that.
Oh, okay.
I think that it identifies the issue a little bit more clearly as to what issue we're grappling with, which is that these notice of appeal things we're trying to take a position to disfavor them. And I understand it's shorter to cut that language, but I think it's a little clearer to cut to have the extra language so that the reader instantly knows what we're dealing with. I'm not going to fall on my sword about that, but that's my preference.
Sure. Let's see. I've got Don Elliott in the queue, then John Siegel, then Michael Hertz.
I'm fine with Michael Hertz's suggestion that we limit this to providing for review in a court of appeals, and then of course we don't really have to get into the issue of complaint. I do agree with John Duffy that we should keep in rather than a quote notice of appeal, because I think that makes it clear what we're really doing here.
Wonderful. Okay. Jonathan, you're next. John Siegel, you're next.
Thank you. While you've all been discussing the wording, I have been going back over all my data to see whether petitions for review are ever called for in district court, and I have found one instance in which they are. It is true that this is mostly used in connection with courts of appeals, but just for the record, the one instance I found so far where it occurs in district court is in 16 U.S. Code 1374 D6, which says any applicant for a permit or a party opposed to a permit may obtain judicial review, ... Such review may be initiated by filing a petition for review in the United States District Court for the district wherein the applicant for a permit resides, or in the U.S. District Court for the District of Columbia within 60 days after the date. So it does sometimes happen. Now, I looked up a case under that statute, and the case says this began with a complaint filed in district court. So even though the statute says file a petition for review, maybe someone filed a complaint because it seems unusual to file anything other than a complaint to start with district court. Anyway, so I just report that that data that I came up with my research, and I'm sorry, but I wasn't really following the discussion because I was looking in statutes.
That's very helpful though to know. Appreciate it. Bobby, if you could take away the line through rather than a notice of appeal, thank you very much. Next in the queue, I've got Michael Hertz to be followed by Bill Funk.
I'm agnostic on what we file as something in the district court. The reason I would get rid of rather than a notice of appeal, and like John, not a hill I'm going to die on in the slightest, to my ear in ACUS speak, that's preambular language. And the whole point about explaining the context and the justification of a particular recommendation is that's what the preamble is for. That's what we do. And then in the recommendation, it's clean, crisp, and just says, this is what you should do. But like I say, if people want it, it's totally fine with me.
I will say as an educated non-litigator, I find the additional clause helpful in understanding what's trying to be accomplished. But that's just me. Bill Funk to be followed by Sharon Buccino.
I'm agnostic as to including or not including rather than notice of appeal. But if we're going to limit 3 at this point to review of Court of Appeals, would it make sense to have a second sentence that says when drafting a statute providing for review in a district court, Congress should provide that the review be initiated by filing of a complaint, so that they don't do something like a petition review that they don't recognize.
John Siegel is our original drafter. Do you want to weigh in on that?
You know, again, that would get that gets rather away from what I thought we were getting at. I mean, you know, if the committee wants to recommend a uniform nomenclature, I mean, I guess my main interest, if we were to do that, would be that 4 should again specify. I think the main point of my original thought on this whole topic was people should not lose their right of review because they use the wrong style on the document that with which they initiate review. And my research of the cases found that usually they don't, that if the statute calls for a notice of appeal and someone files a petition for review, the courts are willing to treat that one as the other and vice versa. But I did find some unusual cases where the court said, no, we're not going to do that. And so my main focus was recommendation 4. And if we specify a uniform format for anything in 3, my main interest would be to say in 4, we should say, but if you file the wrong document, the court should take it anyway.
Sharon Bacino?
Yes, and I just offering some empirical information regarding, I am concerned, and I guess I would like some clarity, and just to introduce myself, I practice as an attorney with the Natural Resources Defense Council. So the Wyoming District Court, Federal District Court, does actively use a petition for review process for agency action, and it does cause some confusion. So I agree with the recommendation that the goal should be to avoid a limitation on judicial review, but I did want to share that piece of information related to where I'm not aware of it being anywhere else, but it is in the local rules of the Federal District Court in Wyoming. It's 83.6A1.
Alan Morrison, please.
Sharon, that's very interesting. You might want to call to the district court's attention, or perhaps you might want to not do it, depending on the district court's likely reaction. The advisory committee to the civil rules has been spending 3 years trying to deal with a very more significant problem with Social Security cases, which really are totally reviewed on the record. And they're in the process of promulgating rules that will specifically create an exception. And if you look into that, ACUS has done a lot of work on that, and the Civil Rules Advisory Committee has done a lot of work on that. So if you needed some ammunition because you didn't want to have to treat it as a petition for review, I think that would provide you with a lot of help on that.
Okay, thank you. And from my perspective, the problem with the petition for review process is it means there's no complaint filed, and so in fact, the filing has no substance as to the claims. So it's a problem both for somebody who's trying to follow what's happening. It's just happened recently related to the oil and gas moratorium that the Biden administration has initiated. There's no substance to that petition, yet the litigation proceeds and you don't know the claims until there's briefing on it. So thank you, though. I will look into that.
So at this point, I mean, the message that I am hearing, and maybe I am misunderstanding this, and if so, then I apologize. But it seems to me that item 3 is, sort of advice to Congress in terms of terminology in labeling to try to achieve a certain amount of uniformity in order to reduce confusion. Whereas item 4, recommendation 4, is aimed at also saying at the same time, we don't want somebody kicked out of judicial review because they put the wrong label on a document. Is that a correct summary, John Siegel?
I agree with that, yes.
Okay, at which point, one of the suggestions that was made was that to the extent that 3 is referencing review in a court of appeals and saying use the term petition for review rather than notice of appeal. And yet we are hearing about confusion with respect to district courts. Whether it was the original intention or not, I don't know if this is supported by the source book, but it sounds as though it is, that perhaps it is appropriate to add a sentence relating to district courts that is largely parallel to the existing sentence in sentence 3. But add a new sentence that says when drafting a statute, providing for review, and if in a district court, Congress should provide that review should be initiated by filing a complaint rather than a petition for review. I heard that suggestion from somebody. We then kind of let it drop, but it does seem to have a certain amount of, both parallelism and also purpose to it. I think we should have at the end of that sentence after petition, we should have filing a complaint rather than a petition for review. For those people who have been weighing into this discussion or anyone else, does that seem sensible, or are there problems with that sentence?
Kristen,
Matt, go ahead, please.
I like what was done there. I just want to, maybe I could just turn to Alan, see if he recalls what language the Civil Rules Advisory Committee is using. On the Social Security context, I just wouldn't want to do anything at cross purposes with what the Judicial Conference may put out by way of an amendment to the Federal Rules of Civil Procedure.
Absolutely, very good point. And John Duffy has his hand up too, but since Matt particularly directed that question to Alan, do you have thoughts?
Yes, the Social Security statute itself provides for filing of a complaint in the district court. So that issue wasn't squarely presented there, but they are treating, what the rule does is it now provides for a shortened version of what will satisfy the words complaint. And they got around the problem that way. So I don't think they've in the sense that they've recognized that the complaint is the right answer. That doesn't change what we're doing here.
Great, thank you. John Duffy, go ahead, please.
I just want to say, with respect to the original recommendation, which is now just the first sentence in point 3, the motivation there was not just to have consistent terminology. It was to get away from any implication that the Court of Appeals is exercising appellate jurisdiction, which it is not. And that, I think, was the reason that I think I might have been the original instigator of this language. I at least had never thought about the issue that's being discussed about the district court, about whether it's a good thing or a bad thing to call it a complaint or a petition for review. It seems to me that at least I have no dog in that fight. I'm very opposed to calling something that's coming from an administrative agency a notice of appeal in the Court of Appeals, because I think that's constitutionally wrong. With respect to a petition for review or a complaint, for example, Sharon mentioned some points about the specificity of the document and things like that. And I just, I don't know if we've really investigated that and have views on that, whether John's source book supports recommendations about that, or whether that might conflict with something the Federal Rules of Civil Procedure Advisory Committee is doing. So that's why I think I just don't know very much about that second sentence, and think it's very different. I think it's very different. Thanks.
I do gather from what Alan says, and Alan can correct me if I'm wrong, that the second sentence he thinks the second sentence is consistent with what's being done with respect to the rules of civil procedure. Sharon has indicated in the chat that the proposed language addresses her concern. John Siegel, do you think your source book adequately supports the addition of the second sentence?
Thank you. I think I have to say no. I think some further, I'm not against the second sentence, but I do think we might want to do some further research for it. If we're going to have another meeting, maybe we could do some research before the meeting. And I would just like to point out the following. The other recommendation we have about not specifying the content of the document that initiates review, that works very well when we're talking about a petition for review filed in a court of appeals. Part of the point of saying we recommend that Congress not specify the required content is that the Federal Rules of Appellate Procedure provide that such a document only needs to say, here's the decision of which we're seeking review, and it doesn't need to say why. And then Sharon, I believe, was the one who was saying earlier she didn't like the fact that when a petition for review is used in district court, then it doesn't specify the grounds, and she would prefer that there be a complaint which would specify the grounds. So if in 3 we say you should start with a complaint, it would have a different effect than what we're saying in use a petition for review. It would have the different effect of saying now you will need to specify the ground. So again, I'm not against it, but we should just be aware of that. And we might want to do some research as to how often petitions for review are currently specified for use in district courts. I found one instance in a hurry here, but that's the only one I found.
Okay. Judge Moss is in the queue.
So I like the second sentence, and it's a little hard for me to believe that if I'm understanding what this is doing here, it's hard for me to believe that further research is going to make a difference here, because as I understand it, we're making a recommendation as to what Congress should do in the future in drafting statutes. If that's correct, and this language would be helpful. And even if the Congress has, and I take Jonathan Siegel's comment on this to be correct, if Congress even has used that language in the past, it's not helpful for courts or to litigants. And it does strike me that it will inevitably add confusion in the future if Congress uses the language of petitions for review in the district court. It's throughout the federal rules of civil procedure. It's not just that under Rule 3 an action is initiated with filing a complaint, but all the deadlines that follow under the rules, dates for initial scheduling conferences, all of that flows from the filing of the complaint. The same thing is true under our local rules, certainly, and that all the deadlines that follow afterwards follow from the filing of a complaint. And so it just strikes me as a good thing for clarity to say to Congress in the future, when you're adopting statutes that are providing for review in the district court, it's clearer to use the language of a complaint, and that would be helpful for judges and litigants.
So let me make one suggestion here. Looking at the time and thinking about what we have left to do, I am anticipating we are going to need to at least have a short meeting on May 3rd in order to wrap this up. How about we bracket the second sentence at the moment with a notation that we need to sort of confirm that it's supportable between now and May 3rd, since the suggestion, if I'm understanding correctly, is that that is doable. That we're not expanding the project dramatically. We're really more sort of pinning down the nuances of the research of the existing project. And the only other question that I have is, particularly since the point was made by John Duffy about the constitutional implications of labeling the document notice of appeal, I wonder whether you feel, assuming we keep the second sentence, are we obscuring the constitutional issue with notice of appeal by including that second sentence in recommendation 3, which might suggest making the reference to the district court a separate recommendation 4 in order to split them apart a little bit? Or do you think it's clear enough? Bill Funk, your hand is up. Go ahead, please.
I think it's clear enough, but I think that if we keep the second sentence, and I originally proposed it, we need a sentence or two in the preamble explaining why we're doing it. And I would leave to the staff to do that before the next meeting with brackets around it as well to make sure that we can confirm support in the way you suggested.
Excellent suggestion. I concur. At which point does that, so where we stand at this point is that our first sentence in this recommendation is, when drafting a statute providing for review in a court of appeals, Congress should provide that review should be initiated by filing a petition for review rather than a notice of appeal. We then have the second sentence that has been proposed. It is presently bracketed for further investigation between now and our next meeting. Any objections to proceeding in that way? John Duffy, your hand is up, please.
Well, I agree with you that maybe we should break it into two different proposals because they are really radically different. The one has this constitutional overtone, and we can explain all this in the preamble, but the other is got this other dimension to it. They're just very, very different in terms of their motivations. I don't have an objection to the current drafting of what is called the second sentence, but I think just for clarity, it would be better to break it into separate a separate proposal.
Do you have an objection to addressing it in the preamble as opposed to breaking it into a second proposal?
Well, I thought I think it's best to do it both, to have something in the preamble that says why we're doing this and to have it be separate so that, you know, because the two issues really are very, very different, it seems to me. And if we don't like Congress authorizing petitions for review in district courts, it's because they have this, they sort of don't jive well with the federal rules of civil procedure, and district judges think this is kind of weird and it doesn't, you know, it's sort of strange. But for the other one, I think there's this constitutional implication.
Okay, does anyone have an objection to breaking it into a separate recommendation? Assuming we end up keeping it. I'm not seeing an objection, so how about we go ahead and set up that bracketed sentence as a separate recommendation with the understanding that we will take up that particular recommendation at our next committee meeting, you know, and in the meantime, figure out whether it's supportable, and then also we'll explain both provisions in this way more thoroughly in the preamble. We have been going for over another hour since our last break. So why don't we take a 5-minute break, and then we'll come back and we will try to get through the rest of the recommendations today.
I don't
just to let you know.
I don't feel that strongly about it. I find some of these solutions almost as ambiguous as the problem itself, but maybe that's just me.
All right, we have started the recording again, Kristen.
Thank you, Bobby. We do need to get going again. So, okay. We are now turning to recommendation 4, which we have done a little bit of work on already, or I guess it's the new, it's tentatively a new, it's tentatively now recommendation 5, but only tentatively. We did a little bit of work on it, but we still have a bunch of bracketed issues left to resolve. So, you know, as it's currently worded, it says when providing that a party may seek judicial review, Congress should not specify the required content of the document initiating judicial proceedings, but should instead allow that matter to be governed by, and then bracket. So, you know, there's this first bracket of whether we should replace should not specify with something a little bit fuzzier, like Congress should be aware that it need not specify. I think from the last meeting, the concern was that we, you know, soften the language a little bit so it didn't seem like we were telling Congress what to do. Although we are telling Congress what to do. I will point out that the recommendation we were just discussing, we use the words Congress should. So, you know, query whether this is different or not. But let's address that language about should versus should be aware that it need not before moving on to this to the next bracket. People who think we need to soften the language to Congress should be aware that it need not. Please raise your hands, and otherwise let's go forward. Bill Funk, please.
I like the should be aware that it need not, because it's not in the prior recommendations where we said should. It was really a judgment call that we are making that there is one way it should be done. Here we're saying that, look, there is an alternative. There's already a way that defines what happens for this content. You don't have to do it. If knowing that you think you really need to do something different or in addition, then sure, you can do it. We're not leaving that out. We're just saying you don't have to because there is something already there. Just be aware that that something is there. If you want to change it, that's okay. So I think should be aware is more appropriate.
Is there anybody who prefers should not? Who wants to speak up? Okay, we've got one vote for should be aware that it need not, and we have none, it seems, for should not. So does anyone object to making this change? Seeing no objections, I think the change is going to be made. So then we need to resolve, let's see, we can either have because the matter would be governed by, or should instead allow that matter to be governed by. Let's leave the last bracketed bit, the applicable court rules, the rules of the court. Let's leave that alone for a while and just settle between because the matter would be governed by versus but should instead allow that matter to be governed by. Bill Funk again.
For the same reason as I had the should be aware, I don't think we say that you should necessarily follow whatever the Apple court rules are. But the reason why you don't have to specify the content is because the matter would otherwise be governed by court rules. So again, this is, I think, because the matter would be governed by is better than us making a specific statement that it's better to be governed by court rules.
I guess that does raise one question in my mind. The observation has been made with respect to more than one of these recommendations that ACUS recommendations often leave the rationale for the, for the recommendation to the preamble. Would it be sensible or would it be consistent with ACUS practice to essentially delete everything after document initiating judicial proceedings and leave all of the rest of that to the preamble? Or do we think that it is useful to have language starting with because here? Bill Funk.
I think it's useful because, just as we said, rather than notice of appeal and number 3, or rather than petition for review and new 5, I think it helps explain it here rather than just having somebody to remember what was in the preamble, which oftentimes people don't read anyway.
Sure. John Duffy.
I agree with Bill. If it can be short in half a sentence, you know, you don't want to have a full explanation, but something like this, I think, makes the recommendation clear and pointed and just better.
Okay. Does anybody have any objection to because the matter would be governed by? Seeing none, let's go with because the matter would be governed by, and we will delete but should instead allow that matter to be governed by. There we go. And then we have to resolve the applicable court rules versus the rules of the court in which judicial review is sought. I'm not sure. I'm not sure that substantively there's a big distinction there, but I am prepared to be corrected. Does anyone have a preference there? John Siegel, you're the one who drafted and put it in brackets, so I'll invite you to say what you think in this regard. But Bill Funk, you've got your hand up, so go ahead, please.
Well, the original language was the applicable court rules, and Allison Zeeb, who I assume is still here, was the one who I think suggested the rules of the court in which judicial review is sought. I have no dog in this fight. I think either is fine, but I think the legislative history.
I very much appreciate that reminder. Okay, John Siegel, what do you think?
I mean, I have a slight preference for applicable court rules just because it seems simpler. And, you know, what other court rules would it be? But if Allison is here, she can explain why she preferred rules of the court in which judicial review is sought. I'm not strongly against that. I just have a slight preference for applicable court rules.
Allison?
So it's an interesting discussion because I suggested last time applicable court rules because I thought it was more concise, and that's generally my preference. And the majority disagreed with me and wanted the longer part. So if the mood has shifted, that's great. I'll take that small win.
Well, I got to admit, I think I kind of like the rules of the court in which judicial review is sought because I find it clearer than applicable court rules. But I'm a non-litigator, so you know, I'm prepared to be overridden in that regard. I suppose to the extent that the original drafter prefers the applicable rules, then the question is whether anyone feels strongly about the rules of the court in which judicial review is sought, and I'm prepared to defer to the original drafter. But thoughts in favor of the rules of the court in which judicial review is sought? Jeff Lubbers, go ahead, please.
About applicable courts '(S) rules.
Yeah, that just seems confusing because it seems like there might be more than one court's rules applying at the same time.
Would there be?
When you said S, I thought you said S''.
No, that's what I said. '(S). I meant '(S).
Okay. Pro or con? I don't feel strongly. Okay, it looks like applicable courts '(S) rules is where things currently stand. You know, does anyone have any objection to that at the moment? Okay, with that, let's go on to you know, the next recommendation / question. We have a staff inquiry here about whether we ought to include a draft bill as an appendix. Corresponding to this, we also had a comment submitted, I believe it was by Andy Vollmer, wondering if we want to suggest where a new provision would go in terms of the US Code, whether it would go in Title V, Title 28, or somewhere else. I think Andy suggested Title V, if I'm remembering correctly. If not, then I apologize. But you know, why don't we talk about that here at this point? Whether we've got to, whether to include a draft bill as an appendix, and if so, whether to include a recommendation as to where we put it. Andy, do you want to express your thoughts here since you're on the call?
Sure, thank you. So my concern is that lawyers might not easily find the general statute that we're drafting, especially those lawyers who are focused on the substantive statute. Again, I think you all know by now I do securities law stuff, and there are fairly extensive judicial review provisions in the Exchange Act. I think most lawyers know, oh, but I need to worry about the APA too sometimes. But if this thing got stuck in, I'm just making this up, Title 33, I don't even know what that is, but, my point is, if it's not easy to find, I'm just worried it won't do all the work that we want it to do. So that's my only goal. And I do think it's really part of the APA. And somebody expressed concern about, well, are we opening the door to like a significant revision of the APA? And my little note says, I really don't think so. Can't rule it out, but I don't think so. And my sort of fallback position is that might not be all bad. So those are my thoughts.
Well, I will say that, if you're wrong about that and you open the door to Title V, you might be right that Title V could use amending. But on the other hand, that is opening a gigantic can of worms that likely would not end up making its way through Congress, at least in my view anyway. But John Siegel, followed by Jeff Lubbers.
Thank you, Kristen. I just wanted to address the other question about whether there should be a proposed statute appended. We have done that, in the Section 1500 recommendation project, we had a specific proposed statute, but I just want to point out that, we've taken a lot of time already in 2 meetings just to try to agree on what our description of what the proposed statute should say. And I have some doubt about our ability between now and May 3rd to come up with exact statutory language that the whole committee could agree on. And so I wouldn't really be able to draft it. I'm going to be grading a lot of exams between now and then. So I think that would be a big addition to the project. And I wonder if we could really complete that in one more meeting.
Jeff Lubbers.
I also oppose it for that reason, but also because I think it would become out of date pretty quickly if people started trying to draft something. Maybe some things wouldn't be included, some things would be, and I don't think it would look great for ACUS to have something in its appendix that doesn't really conform to what's happening a year or two hence. As far as amending the APA or not, of course the APA technically doesn't exist. The APA is it's Title V U.S. Code is what actually exists, and it doesn't have to be in the portion of 5 U.S. Code 551 to 559, 701 to 706. It can be in some other available section, number, maybe put a number A on it, like I guess the Sunshine Act did. But, I don't think it has to be in the current confines of what we consider to be the APA.
Ron Levin, please.
Yeah, I don't think the APA is the right place for it. Partly because I think of the APA as a semi-sacred document, constitution-like as it's often called, and putting in a modification like this seems out of sync with its sort of 80-year-old history. But beyond that, it's addressing things that the APA doesn't address. I think Title 28 is probably the more logical place to put it because that's where judicial statutes governing courts would normally be. Section 10 of the APA is just something that was tacked on to what was basically the Administrative Procedure Act. So I think that really isn't the right location. On the other point that was made, I think I was as I recall the section, I think we have had some problems where drafting statutes does lead to unanticipated problems, and I don't think you should do it casually at all. I think they're the unknown unknowns that you might inadvertently screw up, and unless there's a strong reason to do it, I would just describe what we're looking for.
Alan Morrison?
I agree with Ron. By the way, I tried to put my face back up here and I was told that the host has canceled me out. So I don't know whether that's you, Kristen, or Bobby.
It is not me, but thank you for letting us know.
Anyway,
Maybe
I
the
can't
tech
do it.
people
All
can
right.
figure that out.
Do it again now. No, I'm still not eligible. You cannot start your video because, okay, all right.
That was during the break, Alan, sorry.
There we go, there we go. Happy to see your face. Okay.
The last thing I want to, it's only one thing I want to add is, which is on the question of where in the US Code a statute is put, Congress seems to have very much of a mind of its own, and it constantly moves things around for reasons that are inexplicable. But I would guess that Title 28 is the right place, in part because, as Ron Levin said, we're having these problems because the APA doesn't deal with them. And therefore, to put it in the APA would not help solve the problem. But I don't think we should bother with it in any event.
You don't think we should bother telling them where to put it?
Put that or anything else, yes.
Okay, well, I don't see a lot. Ron, is your hand up so you can speak again, or, okay. So I don't hear a lot of appetite for drafting a sample bill as an appendix. So I think we'll move forward without doing that. You know, I hear some support. I don't hear any support, or I hear very little support, I should say, with amending Title V. I hear some support for suggesting Title 28, but not overwhelming support. So consequently, unless anyone has any objection, you know, I presume that, I don't know, maybe I'm wrong here. Presumably Congress has some sense, at least enough sense not to put a generally applicable judicial review statute in a random title where nobody can find it. To me, Title 28 seems obvious enough that they would put it there anyway, but maybe I'm wrong about that. Andy Vollmer?
I guess I think silence is better. I mean, I don't agree with the Title 28 point, but what I'm ultimately persuaded by is that a suggestion is probably close to not influential with Congress. And I thought I'd mention, if people hadn't seen this yet, what I found to be a fascinating law review article that's just come out on SSRN about 3-4 weeks ago, called Congressional Bureaucracy by Abby Gluck and somebody else. In any event, there's apparently this whole big staff structure in Congress that deals with lots and lots of statutory drafting issues, including where to put stuff. And so there's apparently a group in Congress, not members of Congress, but staffers who do this. And they are probably going to have their own mind about it. So I'm happy just to drop it. But I really did have a goal here, which was trying to make it convenient for lawyers to get to the statute, because I think we all would care about that. And I didn't really hear anybody grapple with that point. So, but as I say, maybe the better part of valor here is let's just not worry about it, because we're not going to have much influence on it.
Matt Weiner, go ahead, please.
That office to which, that apparatus to which Andy refers is called the Offices of Legislative Counsel. I just sort of feel the need to point that out. I agree with the resolution here. It's also very likely that the Office of the Chairman will be called upon by Hill staffers to offer some technical input on this subject. And we can certainly circle back with some of the committee members who are engaged on this for input on what kind of advice we give to Congress. The other thing is, I don't know whose call this would be. Is it ledge councils? Is it the judiciary committees? Maybe a combination of both. But there are also some congressional political issues here, because where you propose an amendment, whether you propose an amendment to Title V or Title 28, also affects which congressional committees have jurisdiction over the statute. So maybe it is best that we stay away from that for now.
That seems to be the best idea. I will note for additional observation here, the further staff inquiry about whether any definitions or additional guidance would be needed with respect to the general judicial review statute recommendation that we're about to address. But in the absence of any particular proposal here, or also whether agency action is too broad or vague, I will leave to members of the committee whether they want to take up these issues. But before we, while I'm waiting for people to raise their hands there, let's scroll down just a touch. We've got this recommendation for the general judicial review statute. We've got a few other smaller items here that should be addressed. One being that, so Jeff Lubbers has proposed for item B, whenever, that in line 137, he proposes replacing from with on. I think this is similar to the recommendation that was proposed, or the proposal with respect to recommendation number 2 that we had rejected before, but I'm prepared to stand corrected on that. So, that's the proposal that is in front of us to change from to on. Thoughts or concerns? Am I reading this right, that we should reject it for the same reason we rejected on before? But I'll let others speak to that. John Siegel and then Bill Funk.
Yeah, I have, excuse me, camera on. I have the same comment that I had before, that I think it might somewhat confusingly suggest that the date of publication is day 1 of the review time rather than day 0. Perhaps it would make everyone happier if instead of replacing from with on, we replaced in both places the word starts with the word runs. No, we couldn't do that in the first. We could do it right there. We couldn't do it in the previous one. The event, it runs from the date the regulation is published. I think that's a way that concept is expressed, which is consistent with the notion that that day is day 0, not day 1. I don't make
Bill Funk.
I have a slightly different issue on this point. So to be consistent with the other one, don't we have to do promulgation, amendment and repeal of a rule rather than regulation?
I'm not sure that we did that with recommendation number 2. I think it was later, or maybe I'm wrong. Let's see.
Okay.
Yes, you are correct. That is where we did, where the event is promulgation. I think it was amendment or repeal. Yes, scroll to recommendation 2 and let's see the change there. Yes, we ended up where the event is promulgation. Although at the same time, that was elaborating what we meant by, or at least dealing with a subset of events. To the extent that this is seeking judicial review of a broader collection of agency actions.
No. One says rule, one says regulation.
Oh, I'm sorry. I apologize. I was looking at the wrong thing all of a sudden. Yeah, this is talking about, we should change, if we want to be consistent, I think we do, don't we need to change, actually, this is a different point. Shouldn't we change regulation to rule? Yes, it looks like Bobby picked that up already. So runs from the date. Let's see.
I would have staff just make the 2
have staff make the two consistent.
Make the changes to make them the same as we already agreed on the earlier one.
Yes, even though it's going to require a slight reworking of the sentence, I think that makes sense. And perhaps in item 2, well, yeah, they just need to be made consistent. Okay. Other concerns about this before we go on? Jeff Lubbers, go ahead, please.
Yeah, I missed the first discussion of this, and I just raised this because it's still not clear to me, what the first day is. I guess I heard John saying it's the day after the rule is published in the Federal Register, and I'm not sure that makes that any clearer. Although I appreciate the effort, but I mean, how do we know whether the date is published in the Federal Register is date 0 or date 1? I mean, we have to be a little more specific somehow. The date, the first day of the time period is the date the rule is the day after the rule is published in the Federal Register. I mean, it's got to be a way to make this a little more precise. But I confess that my first effort failed, I guess. But.
John Siegel, go ahead, please.
Well, Jeff, I mean, first of all, thank you for these comments. It's useful for people to call attention if the recommendation is not clear. I think the answer is found in A, if Bobby could scroll back up to 4A, that we recommend that normally Congress specify these things by saying that review may be sought within a certain number of days after the event. So the way to specify the time is to say it can be done, within 30 days after the event. And then B says when the event is a rule, the event should be the date the rule is published in the Federal Register. So that tells you what the event is. So maybe you're still right that B needs to be reworded somehow. But I think there are two things. There's what is the event, and then how many days do you have from that event? And A has advice on how to do the latter, and B is about specifying what the event is.
It's the date 0 versus date 1 issue that sort of bugs me.
Mm-hmm. I think the concern that was raised earlier about using the word on is that using the word on, the time starts on the date the rule is published, is inaccurate to the extent that the clock actually starts to run the following day. So we can't just fix it by replacing from with on. That doesn't necessarily mean that we shouldn't revise this and as well as number 2 for clarity, but that's the problem with just replacing from with on. I've got Alice and Zeev in the queue, and then Ron Levin.
So I think Jeff's concern about B, at least when we're in the district court, is answered by the Federal Rules of Civil Procedure. Rule 6 says how to compute time, including when the time is set by statute. It would make clear, would resolve Jeff's concern. I actually don't know if it's in the Federal Rules of Appellate Procedure or not. If it's in both, then I don't really think we need to worry about it. If it's not in FRAP, then maybe we could do something by reference. Either
what does it say? What does it say?
It says when the period is stated in days or a longer unit of time, exclude the day of the event that triggers the period, count every day, including intermediate Saturdays, Sundays, and legal holidays, include the last day of the period. But if it's a Saturday, Sunday, or holiday, the period continues to run until the end of the day that is not a Saturday, Sunday, or holiday.
Yeah, that's clear. If you exclude the day of the event, yeah.
But since these are all, when we look at it and when we have to decide how to litigate, at least when I'm in the district court, this is the rule that I would look at it. It doesn't need to be in the statute because FRCP 6 tells me the answer.
Yeah, it's in the appellate rules as well. It's Rule 26A.
Ron Levin, please. Ron, you just remuted yourself. There you go.
Got it, yes. So I was going to suggest the language you could use in B to clarify is the time refers to the number of days after the date on which the rule is published in the Federal Register.
So whenever a specific judicial review statute provides that the event that starts the time for seeking judicial review is the promulgation of a rule, the time refers to the number of days after the regulation or the rule is published.
The date on which the rule is published in the Federal Register.
Yes, I was actually going to make the observation there, since we had this extensive discussion before about the phrase, the publication date for the rule in the printed, the publication date for the rule in the Federal Register should, instead of saying is published in the Federal Register, should we say the publication date of the rule in the Federal Register?
Yes, in fact, I raised earlier the question of whether something goes on the web on a different date from the date at the top of the page, and I think your phrasing addresses that.
Yes, and we had that discussion again while you were you were out.
Okay, then I accept my own as friendly my own idea.
Okay, so starts. Let's see. The time refers to the number of days
following or after the date on which
after the publication date.
Yes.
Gotta say publication date.
Yes.
That's our specific trigger. The publication date of the rule, or for the rule, excuse me, for the rule in the Federal Register. And actually, I take it back, it should be of the rule, because that's what we decided before. Okay, so whenever a specific judicial review statute provides that the event that starts the time for seeking judicial review is the promulgation of a rule, the time refers to the number of days after the publication date of the rule in the Federal Register.
Yeah, and you can cite to the rules that have been mentioned earlier in the preamble.
Sure.
Person.
And can we just rely on the Committee on Style to make a corresponding adjustment to recommendation 2? Allison and John Siegel, I'm not sure if your hands are up because you have something to add, or if they're newly raised, or if they're old. Allison has lowered her hand. John, you've got yours up still, so let me call on you.
Mine is new. If everybody is happy with this, I'm sorry to be disruptive, and if people like this, I think it's fine. But again, in keeping with my thought that A is about the time and B is about the event, I would just like to suggest as an alternative that it should say wherever a specific judicial review statute provides that the event that starts the time running is the promulgation of a rule, the event shall be deemed to occur on the publication date of the rule in the Federal Register.
The event shall be deemed to occur.
Right. So
that's better.
I like that better too.
Because as I say, B is about the event, A is about the time.
Sure. Jeff, are you okay with this? Since you were the one to raise the objection in the first place.
I'm still trying to put A and B together here, but
you should also ask Ron, since this is in the nature of
and Ron Levin, yes, indeed.
Yeah.
Suggested.
I am neutral on the event issue. I was only speaking to the time issue.
Shall be deemed to occur on the publication date of the federal of the rule in the Federal Register. Is everybody happy with this language?
You might have to go look at 2 again to see.
Oh, I mean, this was my question. Is everyone okay with the Committee on Style revisiting recommendation 2? Alan Morrison, go ahead, please.
I have my standing anti-deemed objection. How about the event shall be the date of publication? But I'll let the Committee on Style find a way to get out of deemed. I don't want to have the meeting.
Actually, I
It'll be the publication date of
the event shall be the publication date. Except the event is actually the publishing of the rule.
The event shall be the publication of the rule in the Federal Register. That's the event.
That's the event. Sure.
As long as we get deemed out of there, I'm okay. Tell my students deemed means.
How about the event? How about the event date? Yeah. Shall be the publication of the rule in the Federal Register.
Yes, that works. Thank you.
Okay, and Committee on Style can tackle recommendation 2 to make it parallel. Further objections to proceeding in that way. Okay, seeing none, let's see. I next have, with respect to item C, a question about whether to make the sort of the two parts of this item C parallel to one another. I'm not sure what the language on that would look like. I know Jeff had raised a concern, and so I'm not sure, Jeff, if you can elaborate how you would like to see it rewritten.
I'm a little bit lost right now. So where are we?
We're on item C. Ron Levin, go ahead, please. I mean, the concern that has been expressed is that perhaps the two separate parts of this sentence need to be made consistent or identical with one another. And I don't really have any thoughts in this regard myself, but Ron Levin, your hand is up.
Yes, I wanted to belatedly get back to Alan's point, because I think actually the sense of deemed was correct, because we're not talking about a descriptive statement that A equals B. We're saying treat A as comparable to B. Now, I understand Alan doesn't like the word deemed, fine, but you could use the word treated instead, and
it's okay.
Accomplish the same sense.
Treat is okay.
Well, okay. You know, I guess the question, Ron, at this point is, do you have an objection to the event date shall be the publication?
Well, I think the sense of the sentence is that we are making a recommendation as to how you should treat it, not stating existing fact. And I just wonder if that is sufficiently clear.
So should be treated as the event should be treated as the publication?
Good with me.
I find that unclear myself.
Okay, well, I don't want to press it. I think it can be.
Maybe the event shall be treated as starting with, or starting from the date, starting with the publication. I don't know, I see Alan's problem with deemed. I'm not sure treated helps.
Well, if people think that the other one was clear enough, I would not press my thought.
Let's go back to the event date shall be, and you know, if somebody wants to tinker with it further, we can maybe revisit it in May. Jeff, have you figured out what your concern was with respect to the two aspects of C?
No, I don't think I did have any questions about that, did I?
Okay, maybe I misunderstood from your comments, and if so, the comments that you submitted, and if so, then I apologize for that. You know, since this is actually, you know, it's also labeled as a staff inquiry. Bobby, I'm not sure if you have any light you can shed on this. Go ahead, please.
Yes, this along with an earlier comment about the definitions, we were sort of teeing up in preparation for a draft bill, but because we're not going to be drafting a statute, these issues are a little less important now, including, I think, this one.
I see. I see. Bill Funk, you've got your hand up. Please go ahead.
Are we on C now?
Well, I think we're on C unless you want to go back and revisit B.
No, I'm on C.
Okay.
And here we have the question of, again, statutes authorizing judicial review in a court of appeals. I mean, in other words,
yes,
we made changes
to the
there.
extent we're talking about notice of appeal, sure. That would be parallel with what we had done earlier.
And then in the second part of the sentence, whenever a party seeking judicial review styles the document initiating review as a notice of appeal, seeking judicial review in a court of appeals. Styles the document initiating as a notice of the court shall deem a petition for review. And then the question is, do you need either a new D that addresses the same issue with respect to complaints and petitions for review in district court?
Good question.
In other words, I mean, if somebody files a notice of a petition for review instead of a complaint, should the court treat that as a complaint and vice versa? I mean, in the previous recommendation, it was about what Congress should do in terms of writing things. Now we're talking about what courts should do in interpreting existing statutes. So, and we had at least the consistency issue of at least one statute that said petition for review in a district court, and what happens if the person files a complaint instead.
Sure.
So I would leave the staff.
We have not yet resolved, because we have not yet resolved conclusively whether we are keeping that additional recommendation with respect to district courts.
I agree. But in other words,
why don't we?
I'd put in bracket a new recommendation to be drafted by the Committee on Style, the staff, to parallel what we had in the recommendation to Congress.
Yes, I think that makes sense. So we would be paralleling the bracketed, I believe if I remember correctly, it would be the tentative new recommendation 4 that is bracketed currently. Okay, I've got hands from John Siegel and then Alan Morrison.
Thank you. A couple of responses to what Bill just said. First of all, over the break, I sent to the chair, both of ACUS and the committee, the results of some research I was still doing on the fly, and I found at least 3 statutes that authorized seeking review by filing a notice of appeal in district court. So just so people know that that does exist in at least some places. So, the original point of this recommendation, but not the current draft, but the previous draft, was that I suggested that we tell Congress, provide that a notice of appeal should be treated as a petition for review and vice versa, wherever necessary. This draft, before Bill's suggested amendment, was to try to combine that concept with John Duffy's concept of saying, let's always prefer petition for review. I think if you limit it to Court of Appeals, you would deprive people who are told to file in district court of the benefit of it. So I would not want to limit it to Court of Appeals. And if we did, I would want to have a parallel provision for district courts.
I agree with John. I mean, if you're not going to have the one that deals with district courts, then maybe you don't want to limit this to courts of appeal.
So we are about out of time. I don't think we're going to get this wrapped up at the moment. I want to give Alan Morrison a chance to say his piece, but I think one of the things we need to do, since we're still grappling with what we're going to do about that tentative recommendation 4, I think between now and our May 3rd meeting, we need to come up with how to make sense of this item C in conjunction with the tentative recommendation 4, so that we can start our next meeting addressing that particular issue. With noting that by my clock, we have 2 minutes left. Let me call on Alan Morrison and then Jeff Lubbers.
So I'm not at all sure that we need tentative recommendation 4, but even if we do, I don't think we need to put a parallel provision here. Any lawyer who's admitted to the federal court bar who files a petition for review and instead of a complaint probably doesn't need our help. And I don't know that John Siegel found any instances where somebody lost a case because they got thrown out or told to do something. I think it's pretty clear that you have to file a complaint in the district court, and we don't need to make a recommendation, have Congress make a recommendation, but that's just my view.
Jeff Lubbers?
I think I'll withdraw my comment.
Okay. With that, we really are out of time. So I want to thank the committee for all of its time and attention today. We do have another meeting scheduled for May 3rd, I believe at the same time from 11 a.m. to 2 p.m. Eastern. Bobby is nodding his head, so I trust I have that correctly. I will also call to the committee's attention, if I can find the right document here, just to put on your calendar, the plenary session is scheduled for June 17th at 9 a.m. Eastern with more details to follow. We will pick up, we will do some additional work between now and May 3rd, and we will pick up where we have left off at that meeting. Thank you very much, everybody. Have a good afternoon, and I'll look forward to seeing you in a couple of weeks.
Thanks, Kristen.